Jim, if you want to call this meeting to order.
Call this meeting to order. Whatever this meeting's called.
Well, it's a workshop with
The workshop, Board of Adjustment and Conference Room A, call to order. Thank you, ladies.
My name is Steve Buckley. I'm Legal Services Counsel for NHMA. And Peter and the rest of the board and the staff here are making me to come make a presentation on ZBA decision making, some of the things that I've learned both as a ZBA member and also representing municipalities over the last 40 years. I've been with NHMA since 2014, and my job is to provide legal assistance to our members. I do that on the phone or by email most of the time, but I also do these trainings. And part of the object here is to get direct training to ZBAs or planning boards or other bodies on the subjects within that matters that they handle on a daily basis. Hopefully you don't have to meet daily, but to the extent you have regular meetings.
So if we have a question on the agenda item before the meeting, can we contact you and get some input on?
It's a very timely question, and that's my next slide. So I'm part of what's known as the Legal Advisory Service. So my job, along with my co-counsel, Municipal Services Counsel, Jonathan Cowell, we are the Legal Advisory Service. So we're available to answer questions for municipal officials on matters within their portfolio of responsibilities, 5 days a week from 8:30 to 4:30. But however, if you called us because you have a dispute with the city council on some ordinance unrelated to zoning, I wouldn't give you advice because it has to be something related to zoning. You're due to zoning board. Sure. And so got our email address. I should change that font so you can read it better. It's legalinquiries@nhmunicipal.org, or you can call us. Some days you may not get through, and maybe a couple of days before I can answer your phone call, but I will also provide the answers by 12. We have a couple of other pieces of information here. We really try to stay out of local disputes, the ZBA fighting with the planning board or city council. I'm sure that never happens. And we also try to not get involved with individual applications. A lot of times we get an inquiry from the planning board or ZBA, how should we decide this case? And I'll say, okay, well, let me try to give you some general guidance on how you address the issues, but I really can't tell you how to make this decision.
That'd probably be the question that we would ask is, we have this issue coming up, so generally what's a guideline or precedent or something like that.
The framework within which you will work that you will make a decision. So that's really what I try to do, as much as possible, get that going in that direction. But many times I may end up saying something like, excuse me, you might want to consult with the attorneys here in-house. You guys are very confident legal talent here within the building, and you can consult with them to get their results. And many times when someone asks us a question, and it is the case that you've already sought the advice of your regular municipal attorney, I will say, we're not here to give second opinions. So if you've got the advice from your lawyer is the one you should stick with, and not, see if you can get a different interpretation of the same thing from someone else. So I try to avoid those things.
It sounds to me like your organization and your services are maybe more designed for smaller municipalities that don't have such questions.
Not really, because we provide really close and very computerized, general municipal legal guidance to City of Manchester, City of Dover, City of Nashua. So it's not just limited to small cities and towns, although I would have to confess, most of our inquiries do come from small municipalities, but we do get a goodly number from large municipalities.
I can just see a large potential for confusion. I suppose Jim speaks to our Portsmouth City Council on a matter, and one of us decides, Stephen speaking. You won't even know that somebody's going to be talking to you. How do we?
Well, what I'm usually pretty good to sniff that out. If someone asks me a question and then I hear kind of, well, we've heard, from somebody else, that that's not really how it works, we want to see what you think. I'll think, oh, so you've already gotten the opinion from the city attorney or from municipal council. And I'll say, hey, you know, that's really not our job to give second opinions. We don't want to interfere with your relationship with the lawyers who will go to court with you. We don't go to court with you, but the lawyers who are on both like that, they might do. Or a hired counsel.
Are you willing to make a call on whether something complies with the law or not?
Well, I'll give you an example. Today, I told you all about what the select board had done in a particular municipality. Certificate of building permit, they were issuing permits to that municipality. And the question was whether or not that was consistent with the fact that before issuing the permit, the applicant should have gotten site plan. So what I will do in that circumstance is generally kind of dial back a little bit and say, well, this is the framework. This is the law that governs site plan review. This is the law that governs issuance of building permits. I would encourage your local officials, whoever they may be, whether it's the select board or the planning board of the ZBA, to comply with these laws. And I will attempt to give that guidance without saying somebody's right or somebody's wrong. That's kind of the approach I'll take. So the presentation today I brought kind of broken down into two parts. I do have the first section where I talk about the right to know law, ethics, conflicts of interest, disqualification, and case studies of conflicts of interest. And then the rest of the presentation is really the role of the ZBA jurisdiction, appeals, procedure, decisions, variance criteria, special exceptions, re-hearings, and appeal. We always feel it's important to give a continuing and kind of continuous introduction to municipal officials on the right to know. But it really is something that embraces all elements of what municipalities do and how they do it. Is, you know, the duty to comply with the fact that the right to know law is part of our Constitution, and it's a statute that is derived from our Constitution. And it requires that all elements of municipal government be accountable and responsive. And the public has the right of access to proceedings of municipal bodies, but also governmental records. So that same concept appears both in the New Hampshire Constitution and Section 1 of 91A, that the people have a right to access to the actions, discussions, records of public bodies, and that be accountable.
So what are the specific experiences that it puts on us as individuals, let's say, speak with each other, how's it going to be zoning board? Just suppose I have a question or lines of somebody's opinion. I suppose I wanted to know that's opinion of something abortion. Am I entitled to or allowed to? I mean, Beth would probably answer my call anyway. The more friendly face. No, I mean, is it legal for me to contact the board member outside of the meeting?
Glad you asked that question, because the next slide really touches on it. And what we're really dealing with in the right to know law is to understand that when a quorum of public body convenes so that you contemporaneously communicate with each other to discuss or act upon, that includes not just taking action, but discussing anything within your jurisdiction that has to take place in a public meeting. So quorum is always a majority. So when you have a majority of the ZBAs together, and you're discussing public business, you must conduct that business in a public meeting. Now, is it possible for one member of the ZBA to talk to another member of the ZBA about an pending case? Well, that's not a quorum, which what I understand, because my experience has been generally under RSA 674 33. There's another statute on the members of the ZBA. Portsmouth is a little unique. You have 7 members on your ZBA.
Right, in 2
Yes.
minutes.
Okay, because in the rest of New Hampshire, there's 5.
Right.
Okay, I don't know, maybe you had a special act that allow you to have 7. I'm not gonna get into that, but so if your quorum is 4, okay, it is theoretically possible for 2 members of the CBA to be discussing public business outside of meeting. I don't encourage it. I would generally discourage it. I would encourage ZBA members to only discuss public business pending application in the meeting room in front of the public. But technically, the right to know law, when you're convened, meaning you interact with each other and discuss. Only applies when a form of the public body is together to do that. So
And what about,
your minimum, your quorum is 4.
what about things that are not specific? Okay, so for example, something that I can. And I'm sorry, I'm not gonna take up the face tonight. But this is something that I think, it's being different tonight. Something that I've been wondering about, almost everybody comes forward to the board with a request for a variance on a large, multi-living unit. Apartment building or something. We'll make the case that it's good for the public cause, it's increasing the housing stock, it's going to lower the cost of housing. And the cost of living. Unfortunately. What is the, and I don't want to talk about that specific. How, is there a way that we can speak with each other as a board on a more general sense, like, what do we think is, what do we think of that line of reason? What do we think of, what is the, I mean, as far as I'm aware, of any particular data that says that Portsmouth had this many units in housing, in fact, real estate prices in such and such a way. How do we weigh, so in other words, weighing those arguments without a factual basis for considering.
Nothing that prevents the ZBA from having a workshop where a planner or some of the planning staff or some outside of the city comes in and talks to you generally about housing needs and creation and the effects on the economy. There's nothing that prevents that from happening. Now you have to exercise some degree of caution, because if you have a pending application that hasn't been heard yet or is in the middle of being heard, and then you have this separate event where you have a discussion about housing policy, you could very easily stray into a situation where your discussion bears directly on what's going to take place with regards to that application. And you didn't give notice and opportunity to be heard to either the opponents or the supporters of that application. They're going to say they were denied due process and the right to be heard on a material part of the ZBA's consideration of the issue. So one has to be very careful. But it does not mean outside, just generally application that you might get, that you couldn't have workshops. I mean, DBAs have workshops. I was, representing municipalities of New Hampshire, mostly with regard to the planning board. The planning board that I represented had a workshop meeting. They were so busy, they had 4 meetings a month. I don't know how often you have, but they had 4 meetings a month. And 1 meeting every month was a workshop. And at the workshop, typically they would have someone come in to give a presentation. For one time, an engineer came in to talk to the planning board about retention and detention bases. There's a civil engineering difference between the two, how they work, et cetera. So, I mean, it's not without, certainly within the bounds of possibilities for a ZBA to have a workshop on some particular subject that would help inform you. But I think that if that workshop subject was so closely aligned to what was going to take place with regard to a pending application, you might have an obligation to notify the participants so that they can have notice and be heard. So just some caution has to be exercised. But again, bottom line, public meeting is when a quorum of your public body convenes. So 4 members are discussing public business. It's going to have to comply with the right to do. And along those lines, just to be clear about what a public body is, because the statute obligates the student to comply with the right to know law to any public body. Now, it's clear to understand a public body in this instance is the Zoning Board of Adjustment, which is legally constituted board whose job it is to ameliorate concerns arising out of the application of zoning ordinance to particular pieces of land. It's your job. That is clearly a public body, but it can also include subcommittees or advisory committees. So if, for instance, let's assume Mr. Rossi, you were assigned as along with 3 other members to convene a subcommittee to conduct some kind of further investigation into housing issues and report back to the full committee the full board about what you discovered. You would be an advisory committee. And in that instance, you as an advisory committee would also have to comply with the right to do. Now, it's not typical that a ZBA has advisory. more typical to see them on planning boards, because planning boards have master plan subcommittee. But it's just useful to understand that the statute applies to the convening of a public body. But convening can also occur in person, by email, by text, and communications outside of the meeting that are used, I have sued, pardon me, should have been used to circumvent the spirit of the law, violates the right to know. So again, I think, if you were having discussions, and here's kind of how we always set it up. If, Mr. Rossi and Ms. Heldridge had a discussion outside the meeting about a pending application, and then Ms. Eldridge then contact Ms. Markinson and say, hey, I was just talking with Tom about this. What do you think? And then Ms. Markinson then contacts Paul and says,
No.
Paul,
Not doing it.
okay, Paul, guess what? I just had this conversation that Phyllis told me about, and she talked, and pretty soon you have a sequential series of communications which are undermining, circumventing the spirit of the law. So I think that's where those kind of conversations could lead to that kind of undermining of the right to know. That kind of
Criminals.
it all started on me.
Yeah.
So I mean, I think generally speaking, like for instance, my ZBA meeting the other day, I'm on the ZBA in my town. We were waiting for a meeting to start. No, not everyone was there. And actually we had 2 people had COVID, so I had to run the meeting with the vice chair. But one of the members who I was appointing to sit as an alternate, he was an alternate, this was a regular member. He really was wanting to talk about this upcoming application. He said, Steve, let's talk about this. And I said, no. We haven't started the meeting. We're not going to discuss it. Let's open the meeting publicly and have the discussions with everyone. Now, theoretically, that's just me having a discussion with a member, but I said, no, we're not doing it. Especially because the meeting's about to start.
What about
That's the second portion of the agenda, two Q&A session.
you want me to wait? I'll wait.
No, go ahead. We might as well get them on the table.
So it also happens occasionally for someone who has an interest in it, will want to talk to one of us in advance. And I always turn those people and say,
Good policies. Don't talk. There's cases on that. It's interesting, a case that we're about the city of Dover where one member who was really trying to help it out had a series of extended conversations. Ultimately, the Supreme Court said that member did not cross the line, did not create a situation where the member had to recuse themselves, but it's just not a good idea. It's something you really have to. So I would not encourage having any discussions directly with an applicant or an opponent. Yes.
I'd just like to make a point, excuse me, about what some and many of us have already been trained by the city attorney, who's very interested in the right to know law. And his opinion is if you have a forum, you have a meeting, whether you did it the right way or the wrong way, it's a meeting and its minutes needs to be kept and published and so forth. But before the meeting, you need to publish the announcement of the meeting within the given time period and all of that. And if you don't do that, you're subject to horrible discipline. I don't know what he was meaning, but the point was that if you have a quorum, you have a meeting.
Right.
And city business can't be discussed if the meeting has not been communicated to the public. And all that. My experience with that was in forming a new committee of the town, which is now known as the audit committee. And you can tell because it's got the A word, it's contentious end to end. And the zoning board of adjustment can be as contentious, and there's frankly in a lot of the cases we hear there's money riding on the outcome. So it can get contentious. But he gave us a very simple rule, which is if you have a quorum, whether it's in City Hall in the meeting room or down at the local beer joint, you know, like sitting around at the table. If you have quorum, you have a meeting. And minutes must be kept and published, and there's no way to get well from not having notified the public. So I don't know where that stands, and that is where I'd like your opinion. If something happens and people are challenging the credibility of an event as a meeting, can they overturn it, undo it? How does that work?
Okay, well, I agree with you 100%, that discussing work business, one of the things that is not true is that a chance social encounter constitutes a public meeting. So if you have a chance occasion where the quorum of the ZBA is present in a public location, that doesn't constitute a meeting. So you could, as my planning board used to do every year, we had a Christmas party at the house of the chairman of the planning board. That wasn't a public meeting. We weren't conducting public business. So
According to our city attorney, who is not favorable, my understanding of it is he is not favorable to audit committees comprised of members of the public. So he was trying to discourage what we were doing as much as he could, and he made sure we understood that what we do can be challenged and can be undone and can be replaced, and we might be held accountable in ways we don't anticipate or like from having attempted to take action on something.
Well, so let me just again emphasize, you know, the one issue that you raised about the chance social encounter, that's not a public meeting, it's right in the statute. Chance occasions when you get together as a quorum of public body don't constitute a public meeting because you're not doing public business. But I think, you know, your issue is, well, what happens if we are together, we didn't give proper notice, and we are conducting public business? What is the outcome of it? Well, the law says that action can be taken to undo any public action taken. That's a superior court judge, and we now have a new agency in charge of right to know violation called the right to know ombudsman. There's kind of two main things that the court system or the ombudsman now can do. They can undo any additional action. So if you took action at a meeting that wasn't properly noticed, or the public wasn't given the right to attend, any action you take can be undone. Whatever you did was thrown out and you start all over. And if someone has to go to court to enforce that requirement, that what you did was illegal, they can be awarded attorney's fees. And then lastly, what the court can do is order two other additional remedies, penalties. Other than awarding attorney's fees to the aggrieved party who brought the case to court or to the ombudsman, the court can order the public body or the individual to undergo remedial training. And the court can also, or the ombudsman now, can impose penalties. So there are civil penalties of, you know, ranging between $250 and $1,500 per violation. So those are the array of remedies that the court can impose. But again, I don't think it is the case that, you know, a chance social encounter is a public meeting. But if you have a committee, it's a duly constituted committee of the city, you know, you should only conduct business public business at public meetings. The other point that I want to make on this particular slide, you know, there can be occasions when you have multiple members of one public body serving at a different public body. It could get complicated. So you have one public body, such as the ZBA. Let's say a quorum of this ZBA goes to a planning board to, you know, present your point of view on a particular application. Don't think you do it, but it's possible. Then you could have two public meetings there. It might be necessary to give notice to the public that both public meetings are convened. That the ZBA will be conducting public business inside a planning board meeting. But again, that's unlikely to occur for a ZBA. I don't think it'd be common that the ZBA would do it. But in terms of your audit committee, you know, generally what I think, you know, Attorney Sullivan is saying is something you should, you know, follow is sound advice as much as possible. Whenever you do a public action or going to take action as an audit committee, do it at public meetings with a forum of the audit committee present. And I just to emphasize that, you know, when you're gonna have a public meeting, you have to give public notice. It has to be open to the public and you have to have meeting minutes. And just emphasize the public notice part. You can have different requirements for public notice. So the ZBA has to give public notice to the abutters 5 business days for the meeting, and you have to publish notice of the meeting in newspaper general circulation in your community. But under the right to know law, the minimum notice requirement is 24 hours posted in 2 public places, 24 hours, not including Sundays and holidays. And then, you know, the open to the meeting, open to the public part, I just want to emphasize what that means. Open to the public has a number of attributes. The public has a right to attend. The public has a right to record. They can video record, they can audio record. And as long as they don't interrupt the meeting, I've even seen public bodies have their meetings live broadcasted by someone who's recording from the back of the room and live broadcasting it onto YouTube. So those are all things the member of the public body can do, and members of the public. The other thing about open to the public, it has a lot of other meanings. One of the other meanings it has is there's no secret balloting at public meetings. So you can't have a secret ballot. You can't vote in secret. And you really don't want to be using your smartphone to send a text to a fellow board member. This is what I think about that app. That is having a secret conversation that should only be taking place with the public's right to hear. And then finally, there are, you know, every meeting has to be recorded. 5 business day of any meeting, you have to have minutes prepared. No, you don't have those minutes approved by the ZBA within 5 business days. But if I came down to City Hall and wanted to see the minutes for the meeting that happened for the ZBA 5 days ago, 5 business days, they have to be available for my review, but those are only draft minutes. And then the minutes that you received as draft, that maybe, I don't know if you post them on your website, but you might post them.
The packet.
What's that?
They're part of the packet for the next meeting, so if you're approval.
Yeah, and I don't, and again, just so one understand, meeting minutes are not required to be posted on municipal websites, but if you do, all you have to do is post approval. So that's a few pieces of information about the right to know. I'm going to move on to conflicts of interest. Any questions about the right to know? Any further questions? Well, conflicts of interest kind of all begin with ethics, and there's a lot of things on this slide, but I say among other things, avoiding conflicts, disclosing financial interests, avoiding criminal behavior. I don't have pointing the finger at anybody, but there are criminal laws in this area. Respecting confidentiality, not abusing authority, treating people fairly and equally, honesty, integrity, and trustworthiness. These are all things which people would associate with ethics. But there is a particular statute that we always have to be aware of with land use board members. It is RSA 673:14. And there's really 2 parts to this statute that merit your attention. Part 1 essentially says no ZBA member acting in a quasi-judicial capacity. When you rule on whether or not someone is entitled to a variance or a special exception, whether you're going to take action to approve or disapprove an appeal of the decision by the administrative officer, you're acting in a quasi-judicial capacity. You're acting like a judge. You're weighing evidence. You're hearing from competing sides on an application, supporters and opponents, and you're weighing the information received and making a decision. That's simply what juries and judges do all the time. If you have a direct personal or pecuniary interest, you are disqualified. Applicant is a relative. If you have an interest, financial interest in the application, the corporation applied for an application, you have a conflict of interest, and you should recuse yourself. But there's another part of the statute that I think also bears some attention. You also have to recuse yourself if you were acting on a similar matter in a jury trial. And so the statute refers to, or if the member would be disqualified for any cause to act as a juror upon this trial of the same matter and any action at law. And what we have is the juror standard of the disqualification is RSA 500-A:12. So if you've ever been asked to sit on a jury, these are the questions the judge will ask you. You know, do you expect to gain or lose? Are you related to either party? Have you assisted or advised either party? Have you directly or indirectly given your opinion, formed an opinion, or you reached a decision? Are you employed or employ any party in the case? Are you prejudiced? And you employ any counsel appearing in the case before you? If the answer to any of these questions are yes, you might have to rethink your ability to participate in that particular case. The more common ones, I suppose, and this is the one that has been done with land use board members, have you formed an opinion before you receive the inputs? I mean, if you come to a ZBA hearing and you read the packet beforehand, and you decided, I am not going to say yes to this no matter what these people say, you may have to rethink, are you being fair to the party who's applied to the relief this on? Or I'm going to support it no matter what, I don't care what the voters say. And I just think that's the kind of thing you have to avoid, because that would suggest that you've already formed an opinion without hearing the evidence in the hearing.
But that, giving your opinion.
Well, okay, yes, I'm asking you to look inside of yourself.
Correct, okay.
And understand that you really try to keep an open mind. And I think it's true, but it also, are you prejudiced to any degree? Well, a prejudice would be, I prejudged that, which I got to hear that. So that is, I think, something you have to be careful about. Yeah,
Is there a standard of what constitutes evidence?
we'll get to that.
Okay.
So I just want to just differentiate between two types of decision making. There's decision making that boards make, which are called legislative, and they're widely felt in policy decisions that you are acting in the public, whereas quasi judicial, you're acting to affect specific petitioners, you have to go to the party, you have to weigh evidence, and you have to be generally different. So what would be a legislative act by the ZBA? Well, I don't know what your ZBA does, but every year, about this time of year, our ZBA is asked to provide to the planning board suggested amendments to the zoning ordinance. We deal with the zoning ordinance all the time. And you see,
Ready? We would like to do that.
and you see things that should be fixed. I don't know if that's happened to you, but I've, our ZBA, we would, send a little note to the planning board. These are the things that merit your attention. Maybe they should be amended, because there are sometimes things that happen over and over again. You realize, wait a minute, this is gotta be fixed.
Can we text it during the meetings?
No texting. Put your phone away. Don't be using it during your.
You're on iPads. You can do it on video text.
Okay, yeah. Please keep the electronic media away from your hand while you're participating. I think that's my point of view. But so, that would be a legislative act. You formed an opinion and you tell your staff, let's send a memo to the planning board. They should amend this person, so the ordinance needs to be fixed. Totally okay. And the fact that you have an opinion about it, that's okay too. That doesn't, jeopardize your ability to make a sound decision on that issue. Clearly, however, when you're acting in a judicial capacity, a higher standard of deference to the facts that you hear and the presentations that you receive. So I just have this little kind of formula that just to keep in mind, if you're dealing with acting in the official who is disqualified participates in a case, and whether or not they have to accuse himself, whether it's legislative or quasi judicial, it's a legislative decision. There are cases like this. Let's assume you had a personal or pecuniary interest that you propose to staff to change a particular part of the zoning ordinance. Now, it's not a case that's pending before you, but you really wanted to push this because it's going to help various ways in which would benefit you, but not directly, but indirectly, let's just say. So that's a legislative act on your part. Your vote to propose that, let's assume the rest of your ZBA members say, we're not going to propose that amendment. That's going to directly support you. The court would only invalidate that action. The ZBA did not propose that as an amendment. If the vote of the conflicted member, had a deciding impact. But a quasi judicial decision, if a member clearly should have recused themselves, they prejudged it, or personal or interest, any way in which they participate in decision making will invalidate the whole case. Any decision made is invalidated, even if that member's vote did not have was not an outcome determinative. So the courts are really jealously guarding that indifference standard and will invalidate action by a ZBA if a member just is participating, even though that vote did not, cause the outcome to go one way or the other. So that's just one thing to keep in mind. Yes.
Is there a standard by which they determine indifference?
Well, let's look at some cases. I do have some cases here. But let me get to the cases, but I just want to mention a few things about if you have conflict of interest, there's a difference between recusal and abstaining. So just would mention when you are looking at a situation where it's possible you have to get out of a matter pending before the board, generally you want to be recusing yourself. An abstention is where someone just decides not to vote. Generally speaking, I don't encourage board members to abstain because you're appointed or elected to fill a position, vote on matters, not to abstain. So if you don't want to vote, you really should do it for a reason. I have a conflict, I'm going to recuse myself. And recusing is really the remedy to avoid a conflict of interest, not abstaining. Other things I want to say about avoiding a conflict of interest. You should know that the ZBA, all land use boards have the ability to ask their fellow members for an advisory vote. So you might have a situation where you're not sure whether that circumstance requires you to recuse yourself. You can ask your fellow board members, these are the facts. This is a long lost, fifth cousin I've never seen in my whole life, who's the applicant. I don't really think I have any, direct personal pecuniary interest, even though I am distantly related to the applicant. What do you all think? And your fellow board members can then vote and give you direction. Now, what I would say is, yeah, it's a very distant relative who's the applicant, but it's always safer to recuse and err on the side of caution. But that is one way to get direction from the fellow board members. I would also say, generally, you want to recuse, as I said, not abstain. I would also encourage people to avoid giving opinions on any matters before the board on social media. I would say avoid social media like a plague, and if necessary, disclose, remove yourself, and generally err on the side of caution. Now, the first case that I've got here, and we're kind of, I don't know if you can move that toolbar up.
Yeah.
Yeah.
Yeah, I had it actually.
Yeah, that would be great. Okay. So the first case is Winslow versus Holden, which is a very interesting case. It goes back to 1984. It's a classic situation where someone wasn't on the planning board, but knew about a case that was coming up, was vehemently supporting the project, voiced his opinion before being put in the planning board, joins the planning board. Now he's on the planning board, had previously expressed an opinion strongly supporting the project, and then he votes in favor. The vote is 6-1. His vote did not determine the outcome. Superior Court reversed the planning board decision. Supreme Court agrees and said, it would have been necessary for the planning board member to show that he was different. Indifference being measured by how do we assess the evidence that the court had. So there's no one standard what is deemed indifference. In the Winslow case, it was demonstrably presented as evidence. This member had voiced his opinion before the hearing. When he wasn't a planning board member, he was supporting the project. And there was no doubt that that's what happened. And so the real issue was whether, his vote didn't have the outcome. Supreme Court said, doesn't matter. The quasi-judicial decision-making process, his mere participation was enough to disqualify him. Jury before, and invalidated the entire decision. So again, I don't know what you would say what constitutes indifference, but there's a couple other cases I want to mention that kind of would help answer the question. Now I've lost control, Peter. Maybe.
Oh. It's weird. But no.
Yeah. Can you forward? There you go, yeah, okay. I'll just have you forward the slides.
Sure.
Or you can put it down there, that's fine. Hold on. Still not working. No, yeah, you can just forward. So the next one's the Robert Foley versus trustee versus Enfield case. And I think it's instructive because it also touches on social media and also perhaps helps answer the question that Mr. McDonald has about what constitutes a difference. So in the Enfield case, the ZBA chair, this is a ZBA case, the case was pending. And the ZBA member, ZBA chair was really concerned, does precedent in how we could make decisions in the past and how that affects our view of the current case, because that play a role in making a decision. And so there was a hearing, and then there was going to be another meeting, but in between that hearing and the next meeting, the chair of the ZBA posts a message on PlanLink, and PlanLink is an electronic message board maintained by the Office of Planning and Development, where he asked that question: does precedent binding prior decisions by the ZBA, they're binding on us going forward, making a decision on a similar case? Now the ZBA ended up denying the rehearing case after the chair's email on a different ground in terms of why the variance would violate the spirit of the ordinance or promote overcrowding in this particular instance. So it was the applicant trying to get permission to put a use in that was going to, from the point of view of the ZBA, cause overcrowding. But after the case was appealed to the Supreme Court, the applicant learned, wait a minute, the chair of the ZBA had this ex parte, that is communication material to the case, that took place outside the hearing. So the theory is that everything that should be heard or can be heard or ought to be heard by the ZBA should take place in the hearing so that all the members can hear it. And then those who are participants can hear what's going on. So they can all weigh how the board came up with its decision. And the Supreme Court said, well, it didn't look like what the chair of the ZBA inquired about or received answers from the listserv had any material impact on its decision making. So the case doesn't mean you can't post messages on PlanLink, but it certainly points out what has to be careful, and so caution is warranted. And so consequently, now go ahead, next slide. Even you're frozen.
Click the mouse.
Okay, the Z1 Express case is another example of a similar situation, but it was a ZBA-like action being taken by the planning board in Manchester had a conditional use permit process. The conditional use permit was actually going to approve a gas station in a controversial area near a number of homes where all the homeowners were well organized and opposing. And so they had, as the case may be, a website, a Facebook page where all the opponents to this new gas station were posting messages and suggesting things that be done to make sure the planning board doesn't approve it. But after the public hearing portion of the matter being heard by the planning board, but before the board entered final deliberations, two members of the planning board, one of whom was an alderman, posted a message on the Facebook page of the opponent saying, we support you, we oppose the project. And that raised the question, were they truly indifferent at that point? So one of the members who voiced that opinion on the social media site, at the next occasion when the planning board was going to vote on it, was asked to recuse himself. You formed an opinion, you've already decided this case, you haven't kept an open mind. No, I haven't, I'm perfectly fine, I can go ahead and vote. And he went ahead and voted. Now, of course, the case gets appealed to Superior Court. Superior Court said, wait a minute, you did not enter deliberations with an open mind. And that made a very strong suggestion. You weren't indifferent, consequently. They threw the case out and make them start all over again. Yeah. So that's just another way to look at the concept of indifference.
That causes me to raise the question again, what is the standard for determining indifference? Who said?
Well, that you're not vested in the outcome of the project.
He basically had a definite opinion about how it should turn out prior to the vote. Like if even if it's a small opinion or a big opinion, it's not indifferent. But you can speak on it.
Well, okay, here's another example. So here's another example. This is not this case, but another one where there was a long series of hearings. hearings in front of the planning board, this is the town of Candia. And in that particular case, the board had finalized its public hearing process. And the next meeting was when the board was going to deliberate and make a decision. So one member went home and really thought long and hard about what he heard as the evidence and sat down and he composed some thoughts. These are my thoughts. These are the issues that I think are of concern. You know, these are the matters we have to address. And then came to the next planning board meeting. Everyone was going to deliberate. And when he was asked his thoughts, remember Mr. Buckley, let's say, he said, oh, well, last night I sat down and proposed these thoughts. These are my thoughts. These are the things that I think you have to consider. And this is the direction we should go and make a decision. Now, the court in that case did not say he was already judged the case, violated the obligation to participate in the decision-making process with an open mind. That the court said, no, that's what you want a board member to do, to think hard about the case, develop some notes and thoughts, share those thoughts with his fellow board members, and then participate in an active discussion and make a decision. Now, is there a fine line between what that member did and the alderman who posts the message on the opponent's website? I support you, I oppose the project. I think that's pretty clear. The alderman is not being indifferent. Now, the planning board member who composes a thoughtful series of questions, suggestions for board action, I think that's consistent with your obligation to be a thoughtful decision maker. But I don't know that I can come up with a bright line rule. This is indifference versus this is prejudice, or already forming an opinion before you make a decision. These are just cases that give us some guidance.
Because it was still a while west.
Okay, I'm not sure I agree, but that's okay. I work this. Yeah. All right, so that's just conflict of interest stuff. So what I want to now go through is sort of the basic role of the ZBA and the responsibility you have to the public at large. So your main responsibility is the safety valve. The statute and why you have a zoning board of adjustment. The fundamental reason why you have a zoning board of adjustment is that the impact on land from land use regulations is uneven. There's just no way you can craft a zoning ordinance that fairly and evenly addresses the effect of a zoning ordinance on individual parcels of land. This land is unique. Land has so many attributes which are hard to categorize in a fashion that makes sure it applies in a fair fashion to all pieces of land because of the uniqueness of property. So the role of the ZBA is the safety. And we have developed zoning in the 20th century, now in the 21st century, to provide for the orderly management of the uses of land. But the fundamental, the original zoning act that was adopted in the 1920s fundamentally also required, you're gonna have a zoning ordinance, you gotta have a ZBA. You gotta have a functional board that can allow a relaxation of the rules. Without that, you're gonna have a taking, and that's a violation of both the US and the New Hampshire Constitution. So you have this ability to provide relief, and it's relief by way of getting a variance, granting a special exception, or an appeal of administrative decision. Those are all the fundamental obligations or duties of the ZBA. And there are a number of ways in which you can be taking action to give that relief. But one of the things you don't do is you're not the enforcing authority. So if you have agreements with staff or municipal attorneys in terms of how they enforce the rules of procedure or your decision making or your conditions of approval, that's for other people to enforce. You're not an enforcing agency, you're just an interpreting agency and also an application of the rules to decide whether a variance or special exception is granted. You also have somewhat of an obligation, which I think in a city like this was delivered mainly by the staff to assist the citizenry in how to understand the zoning ordinance. Zoning ordinances are complex and they're hard for individual citizens to navigate sometimes. And I think that's why you have a very skilled professional staff to help people come to the counter and have to fill out the application to get relief as they want to proceed with projects they want to approve or get approved. But one of the ways that you enable yourself to have fairness for all concerned, and the rules of procedure. So you have fairly detailed rules of procedure that define how or act on applications. And then, of course, for a ZBA, unlike the planning board, you don't have monthly meeting requirements. The planning board has to meet on a monthly basis. You only meet when you have applications. And then, twice a month. I don't know, how often the planning board has to
Sounds like
meet. Yeah, once a year. Okay, now it's gone again. So what's the ZBA's jurisdiction? Well, I've already touched on it. You do administrative appeals, variance, special exceptions. You can also grant equitable waivers of dimension requirements, special little provision, I don't know if you get those, but someone says, oh, I made a mistake, I put my garage too close to my neighbor's side yard lot line, I didn't know it. My surveyor is an idiot, whatever it is, and they, they have an innocent mistake, and they're 5 feet too close, and they can try to prove, or they don't have to get a variance. Neighbor usually goes along, or they arrange each other's situation and grant the equitable waiver. You can also grant a special waiver of building on class 6 or private roads. I don't know if class 6 or private roads are a big deal here in Portsmouth and the rest of the state, especially in the North Country. It's a real problem area. You can grant also a special waiver for agricultural uses. So I don't know if that comes up here, but there's a special provision of the statute where someone can say, I'm a pre-existing agricultural use. I think this might apply to fishermen and fisher people, where they can get a special obligation of the city or the town to relax the rules a little bit to benefit agricultural use. It's kind of how it works.
Chickens.
it's a special exception.
The way the statute is worded, it refers to a pre-existing agricultural use, and the way that the statutes now work is, you probably have it pretty well covered, but to the extent you have a pre-existing agricultural use, which is not defined in your zoning ordinance as being permitted or not permitted, they're allowed to continue and even expand to some degree, so long as they do it in a way that follows best management practices. But chickens per se, in a residential neighborhood, if someone just all of a sudden says, I'm gonna have a bunch of chickens, that's not gonna be a pre-existing agricultural use.
We have, we haven't any lately, but we have people apply for variance to have chickens. We sort of have a rule that you can have 6 chickens, up to 6 chickens, no roosters that can be food. So for not one of the neighbors.
I would tell you this, that I think you could conclude, this is the way I would spin it out, that it's reasonable for a board to conclude that this would be deemed in effect, if not in writing, but an implied accessory use for a home. That you could conjure up from that point of view that a home is allowed to have some degree of small agricultural activities. Many people have gardens. I have one. It's now extend to some domestic animals. Well, I gotta tell you, there's lots of dogs in my neighborhood, and it's the dogs that bark all night long, not the damn roosters that are barking. Okay, so you just have to, you can conclude that that is a permissible activity, kind of accessory to a home. But I would tell you, if you are consistently granting a variance for no more than 6 chickens, you might want to think about, let's amend the zoning ordinance and make that clear.
Let's move them all into the chicken zone,
Well, I just,
industrial.
if you're consistently doing something and it's not on the books,
Yeah.
you might want to make it in writing.
As you may have suggested, the city council, they adopt an ordinance for chickens, and so far ignored that request, so we just have to kind of soldier on.
Well, and then you have to be kind of developing some, and I would assume that there's some sensitivity, in certain parts of the city with certain lot sizes may be appropriate. In other parts of the city, it may not be able to be. I'm gonna depends on lot size and
One of the examples in this where zoning has been changed. People who disagree with the zoning change have then stormed into the ZBA requesting variances, and the variances are all granted. for a 6-month period until, the planning board and the city council goes, yeah, we better change that back. Because they're going right around your change.
Right,
It wasn't well thought out.
right, so I'm not encouraging that process.
No.
But I would say
It
that
happens.
if you see it, on a frequently enough basis, yes, it's a signal that zoning is not working in this particular instance and may need to be modified.
Yeah.
But I would also emphasize, it's not unreasonable to conclude that in certain circumstances, you could come up with a conclusion that for a residential use, certain limited agricultural activities, gardening certainly, composting, yes, all the people have dogs. How much further is having a dog or a bunch of dogs? I don't know, it's just me, I've got a bunch of dogs in a kennel to having some chickens, And what about, I remember my sister had rabbits, she had a couple of rabbits, there, you have to make some kind of judgment call, at what point have to use, go beyond what would be considered reasonably implied as part of a residential use. But, if someone has a chicken coop with, 50 chickens and a bunch of roosters, wait a minute, that's overboard, yeah.
The roosters.
Yeah, well, I got a rooster around the corner and I don't care about it, but I'm sure they do. But what are you gonna do? Now, you also have the ability to deal with junkyard approval locations. Also, I don't know if that's the case here. Are you the building code board of appeals? Yeah, okay, so you got the building code stuff. And that can be tricky because the building code stuff, you need input from probably the building inspector.
Yeah, that's a different board.
Yeah. So the ZBA hears appeals under the statute, you have to hear them within a reasonable time. The ZBA can impose reasonable fees on people who are, looking for you for application fees. You can also require someone to get a reimbursement for third-party review and consultation. I don't know how often that might be an issue for your board. There could be special cases where you have special input. A number of years ago, I represented a municipality where there was a relatively new issue with regards to installing a cell tower in a particular residential neighborhood. I actually had to hire a electrical engineer for UNH to help develop an assessment as to whether or not you really had to go there or could have gone someplace else. So you can have that need, and you can have the statutory basis to ask for that kind of consultative review and be paid for by the applicant. So what are the decisions that can be appealed to the ZBA? Well, it can be by any person who's aggrieved by any officer, department, board, or bureau of municipality. So it's aggrieved people who appeal to the ZBA. And theoretically, planning board was aggrieved by a permit issued by the building inspector, the planning board could appeal to the ZBA. I don't know if they have standing, but I suppose theoretically they could. In fact, I just had an issue that came up today where the ZBA, well, apparently in this particular town, the town had a planning board with site plan review authority, but the select board on its own decided to start issuing a permit for a use that required site plan review. And the select board, as the building inspector, we shouldn't have done that because the building inspector is not supposed to issue building permits that don't comply with planning board regulations in effect. So planning board could appeal that decision to the CBA, and I think that hearing is going on. So it's any decision by any municipal official or board responsible for issuing permits. In your particular instance, mainly the building inspector. The building inspector said, no, I can't issue this permit. The person can appeal to the ZBA. The person can say to the ZBA, I disagree with the building inspector has said, and by the way, now I might be wrong, so I'm going to ask for a variance at the same time, which is not an uncommon approach that applicants would take. So it also includes any interpretation, construction, or application in terms of the ordinance, but it doesn't include discretionary decisions. So you're dealing with a situation where when the planning board makes a decision, this is what the zoning ordinance means, and I'm sure this has happened here. Someone can appeal that decision to the ZBA, to the planning board, make a proper decision.
Are discretionary decisions encouraged or allowed?
So
It seems though the ordinance is pretty black and white. You don't need much discretion to determine compliance.
So I think, generally speaking, local officials who are doing the code enforcement in the municipality, they have prosecutorial discretion. Not, you can't take every case to court to say this is a zoning violation. So you have to leave that discretionary decision. So if you are aggrieved by the fact that I'm being taken to court about having too many chickens, but when my neighbor's not being taken to court, you can't appeal that discretionary decision. You can appeal the fact that I don't think I'm wrong, but you can't, the discretionary judgment to take the enforcement action, you can't appeal that. But I can certainly appeal the CBA. I think they're interpreting the zoning ordinance wrong. I am allowed to have 7 chickens as opposed to 6. So the effect of an appeal to the ZBA is supposed to stop the issuance of the permit. So if the building inspector issues the permit, and you're aggrieved, your neighbor says you're building the garage too close to the side yard lot line. If I appeal as the neighbor to the fact that it's built in the side yard setback, permit's supposed to be revoked and construction is supposed to stop. You can appeal an order or other enforcement, and that's supposed to stay in proceeding. So if I'm in court trying to stop a code violation, it's not going to. You can normally stop that enforcement action, but if the building inspector says no, you can't prevent me from pursuing this enforcement action. There was serious public health, safety, and welfare concern. You could have a stay that would allow you to. Normally, the stay would not apply, and you can still pursue the code enforcement. Most of the time, it's when you appeal to the CBA, everything's supposed to stand still with the permit, stand still with the enforcement action. Let's go see, there is this mistake that is alleged is correct by having the matter heard by the CBA.
But it doesn't say other proceedings under other land use boards.
No, it doesn't necessarily state, well, let's just assume. Well, let's assume that the planning board has got an application pending. The planning board, let me put that into context. If the planning board makes a decision as to whether a use is permitted, and they're about to, they've made a written decision as part of the preliminary approval that the use is permitted. Someone is aggrieved by that decision. I can appeal that decision. Let's say I'm a butter opposing the project. Disagree that the planning board is right in proceeding to final approval. They've already given preliminary. And now the abutters appeal to the CPA. I think, the way I would tee it up is you behoove the planning board not to go to final approval until such time as we can have the issue addressed by the zoning board of adjustment. And I think you could say that the effect of the appeal would stay final action by the planning board, because the planning board can't approve an application unless it conforms to the zoning board. There's a question out there, and they should proceed to final approval. Your board acts as a decision maker of whether the approval or a variance should be granted or denied. But if someone is denied an application, subsequent applications for an unsuccessful petitioner are limited. That is, if I've applied once for a variance and I've been denied, I can't ask for the same variance ever again, unless it's materially different. That's the Fisher versus Dover case. And it's meant to make sure, once I've had a chance to have the case heard, and I've applied and I've been denied and I've been appealed, it's the final decision. I can't come back and ask for that same variance ever again, unless it's materially different. And materially different could be I change the application. Now, instead of having the garage within 5 yards of the setback, 5 feet of the setback, it's going to be within 10 feet. So it's significantly different. I can move the garage away. But on changing the applicable legal standards could also be material change in circumstances.
So that person carry over to the owner of that property.
Yes, so it gives us the taxes to the land.
So it's sort of it's tainted for everyone.
Right, and so if I ask for that 5 foot setback from my garage and I get denied, I'm stuck. That's not really something I can change unless I
Sell the house to Fred the setback. Fred doesn't get it.
he doesn't get either, but Fred comes in and says, okay, I'm gonna put it 10 feet away and I'm gonna reduce the size of the garage. Oh, that's materially different.
Change.
Right, and so mainly, and that's in part why when you say no, you need to say why you're saying no. Because by saying why you're saying, you're also telling the applicant, if you understand why we said no, you now have the instructions on how to get a yes. And you could apply and say, I've made a materially different application and I can get a yes. Now, they may not want to do that, but that's part of the reason why you give them that answer as to why you said no. So this is a complete inventory of things you have to do as a zoning board of adjustment. So, number one, you have to have in your rules what's a reasonable time to appeal to the ZBA. Because once the permit is issued, there's kind of a necessity of letting the land use process move forward. And if it was agreed, put in your rules, not in the statute, how long they have to wait. So typically you want to have in your rules of procedure, anyone has agreed by the issuance of a decision by the administrative officer, building inspector, or another administrative body has to appeal within 30 days of the decision or the permits. Statute says you're supposed to have a hearing within 45 days of receiving the appeal. But then there's a new provision that's went into effect August 23rd. That's part of the reason why I gave you this document, which is a complete inventory of changes in zoning and planning laws. As of August 23, CBAs have 90 days to make final decision. I'll cover that a little bit more in detail on another slide. Again, in terms of how you do your job, you have to give notice to affected persons. Those listed persons have to be notified by certified mail that notice is requested or verified mail. People have to have the opportunity to be heard. People are required to be heard. And then you have the option to do some other. Your decision has to be based on the fact of the evidence, not something that was received as information from outside the hearing room, but no one knew about it, such as information from the plan link that the chair of the ZBA and Infill received. Decision has to be by an impartial tribunal. You're impartial through the requirements of being disqualified in law of 673-14. And then you have to have a written decision, and you now have to have findings of fact. So let me break down some of these requirements in more detail.
Could spend a little bit more time on the decision based on facts.
Yeah.
This is said there about.
So let me touch on that in a bit. So this new law of time for decisions, so you have this obligation under the statute, this is paragraph 8, 674-33. So you have to make a final decision in 90 days. The applicant can waive that requirement. But the ZBA, in the event the applicant says, I won't give you an extension of time, which they can give you, the ZBA could make a final decision that does not grant or deny, but simply denies the application without prejudice. And that avoids the Fisher versus Dover. So that's an option. And then if the applicant is denied without prejudice, the applicant submits an application in the future. But now you have to do it within 90 days, unless the applicant extends. But if you can't make a decision, you could, deny it without prejudice. So who must be heard in a ZBA hearing? This is all 676:7. So clearly you have to hear from the applicant. You have, the statute says, you shall hear from all butters and holders of those who have conservation, preservation, or agricultural preservation restrictions. So people who have an interest by an easement of that type on the land. The board also has to hear from all non-abutters who can demonstrate that they are affected directly by proposal under consideration. Now, there's a number of things to take into account when you look at that issue. One of the things that the courts have talked about when you consider that issue is, to what extent someone can show they're directly affected, but they're not an abutter. So you would look at a number of things. What's the proximity of the challenging party's property? Are they within 100 feet or are they 2 miles away? What is the type of change proposed? How would the change that's being proposed by the applicant be arguably directly affecting someone who is not a butter but nearby or something. What's the immediacy of the injury that's claimed? So I think most of the time, I don't know what your experience is, if someone's gonna claim off-track impact, they're gonna refer to things like parking, traffic, maybe noise, or it could be smells or odors, obstructive views, yeah, those are the kind of things that they're gonna argue about. Now, that's impacting my view shed or my quiet enjoyment of my property. And someone could say, I have a quiet enjoyment, which is injured by the large amount of additional traffic that might be generated from the subject property. And it's likely that the distributed traffic will be going right on the door and I'll never get in my driveway. Okay, well, that might be sufficient to say that non-abutter has ability to be heard. And then, other than non-abutters who are directly affected, non-abutters and the applicant easement holders, the board can hear from such other persons as it deems appropriate. So that's how the statute is worded. You know, differentiating between someone who just says generally, I'm trying to defend the interests of the beauty of Portsmouth, how it will live and breathe in the future, who would have standing, but they're on, you know, on the opposite side of the city, not really directly affected or unabutter, is really a judgment call. But there's actually been some cases on this recently where the Supreme Court has made clear, you know, ZBA action is not meant to be, you know, an assessment of popularity of what the use is. It really has been based upon how does the use directly affect, you know, abutters or those who are not abutters who can demonstrate that they would be direct.
And the use, so people surrounding a water body, that is, there's a standard for that. So somebody across a pond or a spring or something like that, they may not be technically in a butter, but doesn't the water body itself confer some butter stuff?
Well,
That's-
I'll just, let me just read the statute, but it's easier that way, because I know that there's a reference in the statute, the definition of a butter.
It's a mud flat at the time.
He was talking about it, they were upstream.
Well, it says, a butter means any person whose property is located in New Hampshire and adjoins or is directly across the street or stream from the land under consideration by the local land use. Now, you know, does the word stream embrace a body of water? Theoretically, I suppose, you know, it doesn't say body of water though. It says stream. And that does, I think, refer to a intermittent or, you know, regular running stream. So, you know, I think most of the time the court would fit pretty closely to the statutory definition. But again, the fact that they're not necessarily in a butter, they still might be able to demonstrate that they're directly affected sufficiently that they would fall in the category of being, you know, those who have to be heard.
Yeah. Case some time ago, there was a number of non-abutters that insisted on testifying against the application. Some of these people live 2 miles away. No stream, no road. They just wanted to testify against it because they, I think, had banded together as a group and said, we're going to send the army down there to try to stop the spirits. So in that context, if how would you determine if they're non-abutters? It said you shall hear all non-abutters if they can demonstrate they're directly affected. So could the chair ask these people how they're directly affected by that?
I think you could. And I think you could create a hierarchy of who you're gonna hear from at a public hearing. I think you could, in your rules of procedure, say, we're gonna hear from the applicant. We're gonna open the public hearing. And then we're gonna hear from abutters. Then we're gonna hear from people who are non-abutters, directly demonstrate they're directly affected. And then we'll hear from such other persons as the board deems appropriate. And I think you could do that.
So our general procedure is we hear the application. And then the chair asks people who want to speak in favor of the application. And then we speak against the application.
you want to speak before is the application? Can you vote for the period and the numbers? Yeah.
Well, I think when you're hearing those who support the application or oppose, you could create within each of those two parts, a subset of, we'd like to hear from those butters who support the application.
So you're the voters who support the application.
And then we'd like to hear from any butters who oppose the application. And then you can go to, now we want to hear from non-abutters who can show they're directly affected, who support the application, versus non-abutters who show they're directly affected, who support that, and so on. You can tell, but I think if you're going to go that approach, it's a good idea to, lay this out in the rules of procedure, like how we're going to break down the scene. And then you get to those others, you don't fall into the directly affected category or the abutters. And then you begin, weighing your evidence. And again, I think what you're doing by doing that, you're also giving, a hierarchy of the way in which you'll be weighing that evidence, what weight you will grant. I mean, I would assume most of you would agree that the direct abutter would really give personal information about how the traffic on the road is already bad and it's going to get much worse with this particular use. That has some weight, whereas someone who's 3 miles away, their traffic is going to be horrible. You're going to say, well, does this affect you? Where do you fit into the picture? So you're just giving weight. You're naturally using the evidence from those people who are directly affected to give it the weight, or those who are not affected at all, theoretically, that weight is warranted in the circumstances. This way, kind of way I would tee it up. And in fact, there's a new case here that kind of talks on it. Andrew Development versus Funding. It just came out in September. So it was a case involving a multi-family housing project. Among the reasons why the zoning ordinance permitted the use was whether or not the use would not reduce if not reduce the value of property in the district, not be injurious, obnoxious, or offensive to the neighborhood. And the Superior Court concluded, which the Supreme Court agreed, that the ZBA erroneously relied upon public comment opposing the project to properly base its decision on aesthetics and by judging the application solely on popularity. There were lots of people opposing it, many of whom were not abutters, didn't want to see the project go forward. The depth now, I think, for why it came up at the Supreme Court level is that it was undisputed. The exact same building could be built. We really have the same level of occupancy for an apartment as compared to what was allowed by right, a hotel or nursing. So it was very hard to then distinguish, well, how could you say no to a 70-unit, 6-unit multifamily when you could have 76 individual rooms for people in a hotel or nursing home? What's the material difference? And there was no difference other than what the court said. It appeared that the ZBA relied very much on the popularity. Now that's a harder piece of work for a ZBA. You have a room full of people all saying no to something, and your job is to weigh how are we going to give weight to what are these people saying. Now, if they're all in direct abutters, have very cogent reason why this is going to have a material impact on our use of their property. That's different than if everyone is not an abutter, not even directly affected, and they're just saying, keep our town the way we want it, not what others will be willing to do in your community. That's what they're doing. So that's kind of, I think, what the court was saying in the event.
That's some validity of the argument. Either two for or against.
I think it's the weight. How do you weigh the weight that you will give the evidence?
Correct, like you were saying before, you may have a direct abutter who may have a terrible argument as far as the impact, because none of the impacts he's mentioning has anything to do with the zone or what the ZBA can do. And have somebody who's not a direct abutter, lives clearly outside of town, who actually has a valid argument to say no or say yes.
Right, and hopefully in this particular instance, why the multifamily housing was not the same as a nursing home or hotel was permitted by right. And why therefore, it justified saying no. Now, I think, Thomas, right, you had the question about weighing the evidence, so I have this slide, which gives guidance about that. It doesn't directly answer your question. I think what you're asking is, there are situations where the board receives evidence. I mean, this slide is mainly trying to give you kind of a rubric on how to assess evidence. You receive the evidence during a hearing, you collect it. And I gather what you're saying is, there are occasions when the ZBA receives something in your, as a deliverable that gets into your packet, or you can become aware of it in a fashion that the applicant really hasn't had a chance to consider it. You know, one of the things I would say on that issue, you know, what the town that I represented for both the ZBA and the planning board, they had a deliberate process. You wanted something to be considered an application, engineering report, you know, a submission, a memo, it had to be in the packet. When we got in the packet is, we delivered it to the community development department on the Thursday before the following Wednesday meeting. And then, when it got in the packet, because you delivered it on time, it was then sent to the board members, so they received it by Monday before the Wednesday meeting. They had a chance to consider it. So I guess, you know, if there was a procedure where you had to make sure that those who want to submit information had to follow that process, that would limit these last minute submissions that the applicant has got a chance to look at. Now, you're always going to have occasions where someone says, they come to a CBA meeting, we just got this engineer report. I'm sorry, I would have sent it in previously. Okay, that's going to happen. The problem we're going to face, especially now that we have this 90-day limitation, you might say, well, it's only fair to those who haven't seen that report, have a chance to look at it, consider it, instead of submit a rejoinder. But we're not going to be able to do that, you know, as frequently as maybe we could have in the past, because that's a 90-day deadline. So there's a need to set up procedures where you have to submit things in a timely fashion. So when I did application for the Social Security Administration, I wanted to submit a medical report. I had to have it there 10 days before the hearing. And if I wanted to rely on something that would support my point of view, I had to have it there on time. Same thing happened with the Department of Labor. If I wanted to present an argument on a case that I'm on a trial before a hearing officer, they had to be submitted 5 days beforehand. And then those materials had to be shared with opposing counsel 5 days beforehand. So everyone saw everything that was going to be here in the evidence. So it might just justify developing some very, you know, realistic rules. If you wanted to make a submission, you want to submit a last minute report or make an argument based upon documentation, you know, you really have to get it beforehand. It has to be within a certain time frame. So it's fair to all concerned that all can have a chance to consider and evaluate the information.
So we have situations fairly routine where, especially attorneys presuming an application will pass out information before they start presuming applications. So anybody in opposition to that sort of has no chance to look at it. We really don't have a chance to adjust it if it's more than 2 paragraphs long. Because we're trying to listen to them and read whatever they're saying. So you're saying we could establish a rule that if you want to.
I think it's not a bad idea. You know, is it going to be a hard and fast rule? Maybe. You know, attorneys are in that situation quite frequently. They're told, you know, if you're going to make a trial in Superior Court, you know, the courts will set up a pre-trial management conference and say, you know, we have to have memos of law in support of your argument 10 days before the hearing. And they've got to be submitted in a timely fashion. Now, there's always a need perhaps to relax those rules, but I think that's one approach you might take, is to manage through your rules of procedure how the information is received. And as much as possible, make sure that there's a fair sharing of that information to all concerned. Everyone wants to do with it. Tom is suggesting you come in at the last second saying, I've got the death knell for this case. I'm the abutters attorney, and this is going to kill it. Here's the argument. They lay this paperwork out, and no one has had a chance to see it. And the applicant's attorney is pulling their hair out, right? So I think that's something to consider. I'm not going to say it's going to solve all your problems, but it's one way to consider. You're trying to have a regular routine. Want something to go to the board, it has to be packet has to be received by this time so that the packet can be shared, not only with the board, but everyone else who's gonna come to the meeting, because I don't know, do you post your packets online?
Yeah.
Yeah, so
Yeah.
it's a fairness issue, to make sure the information is fairly shared to all concerned.
We get a lot of public comments that come in. Sometimes I don't see them before I sit down. But we also recently had a case where we got a memo from another department in the city that had a material impact on the decision, and it was received maybe 3 hours before the public hearing. And really delegated one direction in the decision, in my opinion, without any chance for me to have a counter expert on it.
And I think that if I was the applicant's attorney and saw it happen, I would be a little bit unhappy. You know, that would happen. But, you know, again, I'm not trying to direct, you to go a certain way in terms of writing the procedure. These are good things to think about, right, as much as possible, into that fairness in the sharing of the meeting process, and make sure that when you set down, and the other thing I want to say, Mr. Lee, I was in the same situation as on the planning board. There is no way, when I was on the planning board, to receive a 15-page detailed civil engineering report, understand it, read it, and make a decision. I had a planning board meeting, you're crazy, I can't read it and listen to testimony, it just doesn't work.
I think the worst thing is it's surely not fair to us. To put us in that position. And have to deal with that.
So if we, given all the procedural things, we have the option at that point to defer some matter, go back to slide 28. If people felt not.
Or we just. say,
Or you just
"Not
take-
even paper." If you wanna go ahead, we're not, I don't know if that's true.
Well, I mean, so what's gonna happen? What's gonna happen?
Postpone.
What's gonna happen is the person's gonna have this. I don't know what they see this before. They come in, I've got, noise engineer is gonna give an opinion about noise impacts on budding properties. I just got the report from this. The only noise expert in the Northeast, and I can't deliver it. And you would say, well, you're gonna force continue, it can only continue now, to a period within 90 days, so. It is really incumbent on applicants, those who submit, to be kind of schooled and understand, there's a process we have, if that's the route you go. And that things have to be submitted in on timely fashion. If you want us to consider a document of that type, you have to submit it so many days beforehand. Now, I'm not saying you don't take the testimony. People are gonna submit last minute comments.
Yeah.
So I don't know what your process is, but typically what we'll do at a ZBA meeting is we've got email comments. The chairman will say, okay, before I open the public hearing, I just want to say that I've gotten the following letters from, we got a letter from so-and-so, the butter saying it supports the project. I have a letter, another letter saying it opposes the project. Just read them quickly and you can summarize them and say, and they'll be in the materials here. Anyone else wants to look at the letter. So then move on from there. It's a little bit different saying you're taking a comment versus a comprehensive report on a different topic. There's a difference there.
That person could still stand up and give a brief summary of the Senate report without the other side having had that as a header.
And then you can say, I'll just state what I think that report says in summary form, and I'll submit this, and opposing parties are concerned can submit their consideration of that issue. But what you'd be doing is the person would say, here's the noise, that fancy noise report, but it's just going to go into the ZBA's packet for the next meeting. That's basically what would be happening.
Does the 90 days start after you come here?
It starts on receipt.
Receive the application.
So 20 days from
Application
receipt.
deadline.
So you've got 90 days from that receipt. So that's really going to be the critical time period.
So we have some latitude in what we as long as we're consistent.
Yes.
There's some latitude, what we said.
I think, and latitude, try to be, get fairness to all concerned. So just to go through, what, as with this slide, you collect the evidence, you apply legal tests. Now, I think one area that the board has considerable discretion to choose between competing expert reports. That, I don't know how often that happens here, but it's an issue that comes up occasionally. When we have to accept a report, expert report, and is it uncontradicted? But the board might decide in certain instances that, when you're looking at two competing reports, I've seen this on a number of occasions with traffic reports, one traffic engineer just says X, another one says Y. You don't know, which way it's going what. And you have the ability to make your own judgment whether or not those experts are reliable, and one is better than the other, and you will, go with the opinion on the one that seems most reliable. One area that is something you have to be aware of is that if all of the experts say this is so, you can't really ignore it. You won't be in a position to ignore uncontradicted expert opinion. There's one case, in fact, on Condos East, which we always have to recite to people, where the Conway Planning Board really wanted this project to have a second means of ingress and egress. They had one way into the project, but the planning board said, no, we want you to build another road over here to give an alternate ingress and egress to the project. But the town's engineer said you didn't need it. Planning board's expert consultant said you didn't need it. And the applicant's engineer said you didn't need it. So all the experts said, you don't need to do this. And the planning board said, we don't care, we want it anyway. And the Supreme Court said you can't do that. So that's one only area you have to be concerned with. But you also have the power to rely on your personal knowledge. So personal knowledge is something that a board can rely upon, but you just can't ignore uncontradicted opinions of experts. But you can use the authority to hire consultants to assist you in making decisions.
I'm still confused about the uncontradicted expert testimony. Guys, I'm talking about the public health memo that we received with regard to one of the cases. Was that properly considered expert testimony? I think that whole situation was taken so late, and the applicant really didn't have a chance to present contrary. I'm not sure what changed, but they never had a chance to do it.
Well, I think it's up to us to decide whether or not they are an expert. I don't think that we basically, like, I'm an attorney, so or qualify your expert. Something that
But it's hard to
formal
say.
here, but you decide whether or not they are an expert.
They are an officer of the city.
It is a part of
In the health.
Department of Health.
Making a statement about public health.
Yeah,
In the case where land use boards may hire consultants. Consultants aren't free.
right.
Who pays for them?
The board can require an applicant to pay for the cost of special investigative study, including a hired expert at the expense of the applicant to review a particular issue.
Do you have provisions in the ordinances to allow that, or?
Yes, there's a direct provision for that in the statutes governing the zoning board of adjustment. So I think to summarize the decision-making process, I have statute contemplates most instances, the ZBA is made up of 5 members. So for a ZBA, in that setting, you have to have 3 members concur. Now, in your situation, you have to have 4, because that's the majority of a 7-member board. You have to use one consistent voting method. So I don't know what you do, but in my ZBA, what we do is once we've closed the public hearing, then the chairman of the ZBA is a variance. He says, okay, and then he goes through the 5 requirements of the variance. He says, okay, Mr. Buckley, how do you find on the issue of public? I'm gonna find the requirement here. Hold on a second. So how do you find on the variance will not be contrary to public interest? And I'd say that. And then he goes to the next person. how do you find about, the not content public?
We'd be here all.
Yeah, no, that's how we do it, we met, and then, and we do each one. Each
Person
one-
makes the motion, goes through the 5 criteria. How do you do it? Yes,
Okay, all right.
But also in your case, we only have to say met, they don't have to
Yes.
say met because.
Well, we'll get to that.
Okay,
So what we do is we go around, each of us saying, well, whether each of the 5 criteria individually has met or not.
yes.
And then once we've done that, assuming that most of the time everyone has said they do met or not met, we then, someone makes a motion. So for instance, the other night, we did that whole routine about a side yard setback of industrial use to a railroad yard, I'll bring you the details. And I made the motion, Madam Chair, I make a motion that we grant the variance to allow an intrusion in the side yard setback for parcel, blah, blah, blah. And we do this because, you know, there's no material need for this industrial building to be set back more than a certain amount of distance that is safely needed. Because the railroad doesn't object, happy to have the industrial building expand a little bit, so we find that the purposes of the side yard setback will still be met by granting the variance. I mean, I formulated a kind of a motion to that effect, and we just all voted on that motion. And embedded in that motion was the finding of fact that there was no, that the amount of change was, you know, changing the amount of setback from 30 feet to 20 feet. So it was a 10-foot difference, but it was not abutting another use, it was abutting a railroad right of way.
And either the maker's motion goes through the 5 criteria. Seconder, agree, disagree, add whatever their findings of fact, and any board member is free to jump in with their findings of fact.
And then you vote,
And then we vote on the motion that's out there.
the motion that's out there.
And it also precludes people who, I mean, they can always speak, other members who may not agree with the motion, they can just vote no on the motion. Or they can make their, pitch their argument for the same reason.
Well, I guess the thing I would just mention is that you have to have one consistent method. And that might be rules and procedures, and if you change the method, you have to do it with notice, and then you can't, as the statute says, you can't modify it after a period of 60 days, so. The board shall use one voting method, and any change of the board's voting procedure should not take effect until 60 days after the board has voted to adopt the change. So if you wanted to change, you adopt the change, and then 60 days later, begin using the change. But if you're sticking with what you're already doing, you're fine.
In serious system of things that we know before you walk into the chamber, what are we gonna use tonight? Someone say that.
Yeah, well, this is designed to prevent that.
Right.
That you have to have a procedure that's well known, preferably in your rules of procedure, but if you want to change it, you can do it, but you have to wait 60 days before you use it. Yeah, so your decision obviously has to be in writing, you have to state the reasons why you approve and disapprove. You have conditions of approval, most instances, I'm assuming you can give a conditional approval saying, sure, we're granting your use here for this commercial operation, but it'll be subject to site plan review by the planning board or any other necessary requirements that would ordinarily be attached. And then you have issue decision within 5 business days, all which is kind of an administrative process that I'm sure staff takes care of. This new requirement for findings of fact, yes,
So it's still possible to continue to do conditional approvals.
yes. For possible to conditional approvals. And for a planning, for a ZBA, it's mostly, presumably, it's designed to say to the applicant, we're granting you a conditional approval, you're subject to these conditions, and they could be, be a condition, be a theoretically proceedings. You can't get a building permit until you get a site plan review. But you can also have a condition subsequent saying, we're granting your permission to put in this, this Taco Bell, but you can't have operations after midnight. And the squawk box has to be turned off at 10 o'clock, or whatever,
You can always have stipulations.
Yeah, you have stipulations.
Reason.
Yes, everything's gotta be reasonable. Love that word. Okay, so new law, findings of fact, so you do have to now have findings of fact, the statute makes clear, the decision shall include specific findings of fact to support the decision. Or that if you're saying no, you have to have findings of fact as to why you're saying no, but if the board fails to make specific findings of fact. Supporting a disapproval, it's ground for automatic reversal and remand by the Superior Court. So keep that in mind. You don't say why you're saying no based upon findings of fact. And if people are aggrieved by that, they could get an automatic reversal. That's something you have to be aware of. You're already required to say why you're saying no, but now you have to include these are the written findings that support the reason why you're saying.
We've had 2 meetings under the new.
Okay, yeah, all right.
They're painful.
So, some of this is kind of common sense, you know, the ZBA does not have to, you know, accept the conclusions of experts, you're entitled to question, reject the methodology of conclusions of experts. You can disregard an expert opinion. I think the really interesting case was a 3-pond resort case versus the town of Milton. This was a situation where an applicant wanted to put in a significant expansion to an existing campground. So they were adding probably 30% more campsites to a campground. The campground was located on a lake. In order to get to that campground, there was a relatively rural road that led from the nearest state highway to the campground. And it was a considerable issue as to whether or not that road supported the additional traffic. And so the really interesting thing about the ZBA members who provided their own personal knowledge about the fact that I travel that road frequently during August and July, high season for the use of the campground, and it's crowded. And there's a lot of people parked on either side of the road, impairing line of sight and jeopardizing the movement of people who are going on that road by foot. And one of the things that came out, this traffic engineer had done a study in May when the traffic season was much more acute in July and August. So the ZBA members were able to provide that direct evidence that undermines the traffic study, allowing the ZBA to reach conclusions based upon their personal knowledge. You know, even though this was the only traffic study that was available, they were able to use that personal knowledge to say, no, we don't think you've got a sound basis for your opinion. And that allowed the ZBA to support their conclusion that we're going to deny the various questions. So again, some issues to keep in mind about how the ZBA reaches decision.
Excuse me, on the page before, it says, but uncontradicted expert testimony overcomes general member knowledge. How is that not the exact opposite? What am I
Well,
missing?
that's the difference here is that there was direct knowledge that did undermine the opinion of the expert.
Oh.
So what happened in the town of Milton case, 3-pond resort, those members had direct evidence that they were able to show, demonstrated the traffic study was unreliable. And their direct ability to observe movement of traffic during the high season for vacationers demonstrated that the road was not adequate and would not support it.
The general member knowledge.
Right, generally, right, this is very specific knowledge in that particular, but
Let's do.
Because general member could have been here, could be in the same town for 30 years, and their general knowledge of the town could be greater than a specific expert.
I think, you know, I think here, I think the more important, they were acutely aware of how that road was not supporting the existing traffic during the season. And adding, you know, 30% more campsites was gonna make the situation much worse.
Had the traffic study been done in July or August?
Might have been a different story. But it was done at the wrong time of the year.
It was just that study.
Well, exactly, and so what the direct evidence of the members demonstrated that this was not a reliable report.
But when do you see the developer bring forth a study that contradicts his development?
Okay.
Well, look, I can tell you, I don't know, I've seen enough lawyers who sometimes don't read the reports they should read. They've got the golden outcome for their client, but you know, it's a careful examination might demonstrate that what they don't have is supportive evidence. What would happen? That happened here. This is an important concept that I think always bears potential, the Bartlett versus City of Manchester case. So what this case came down to was whether or not the ZBA here, which decided that a particular relief an applicant wanted to get was not needed. The ZBA concluded there was no need for this person to get a variance, and I don't mean the detail, but it had to do with whether a use of the church could be used for housing the homeless and also providing them a place to eat. You know, whether that was a permissible use within that particular zone. So the Bartlett versus City of Manchester case, when the ZBA said you don't need a variance, it's permitted use, that people opposing the project said you can't do that for the CBA. CBA doesn't have that authority. You've got to rule on the application as presented. But the Supreme Court said no. Every variance application contains within it the threshold question: is this variance necessary? And the ZBA can decide, no, you don't need that variance. And this very thing happened recently in front of my ZBA, where there was a situation where a use was near a class 6 road and next to a class 5 road. And we looked at the case, we realized, wait a minute, their barn, that our zoning ordinance only requires a setback from class 5 roads. But the barn that they wanted to build an addition on wasn't anywhere near the nearest class 5 road. It was close, but it wasn't near. And so we concluded you need a variance because you're not building within a certain prohibited distance of a class 5 road. You're only building within a distance of a class 6 road. It doesn't matter. And so you have that power to say, when you get an application, wait a minute, we determined that no variance is necessary. This is permitted use. You have a question.
This sounds like it could lead to overturning planning board decisions in some instances. Have you experienced a high volume of conflict between zoning board and planning board?
Well, I would say that having been on both the planning board for 10 years and now been on the ZBA for 5 years, I would say it's not always the case that they see eye to eye. And they have differences of opinion on how the ordinance is interpreted. But ultimately, it's the CBA's power to decide what the ordinance means, not the planning boards, which sometimes the planning board don't necessarily agree with. Now, certainly we would hope planning board will work in harmony, but really is the job of the CBA to make a decision about what the ordinance means, how it applies in certain circumstances. But this, I think, the evidence in this particular case, I always feel it's important to be aware that you have this ability to say, even though the applicant has applied for a variance, and even though in my case, our building inspector said, oh no, they have to have a variance for this. We went out on a site visit. I don't know how often you do site visits. We went out on a site visit and looked at what they were doing and how it was related to the frontage. And we looked at our planning, the community development director. I said, how did you make this decision? It doesn't make any sense. And the more we looked at it, we don't think they need a variance. So it could be situations where they just didn't understand how that particular requirement of the ordinance applied in that situation. We figured it out from the site visit, eventually said they don't need a variance. So you have that authority to make that judgment. And in those circumstances where you make that so just to spend a little more time specifically about special exceptions and variances. We're all probably very much aware that a variance is something that is permission to do something that's not permitted in the ordinance. You have this 5 criteria, whereas a special exception is the town has decided, the city has decided, this is a use which we will allow if you meet these criteria. I think the big thing to keep in mind is, or the difference between the two, variances are discretionary. Special exceptions, however, if the applicant satisfies the criteria, you're required to grant permission. And that's the big difference. So let me spend a little time to go through the criteria for a variance. Criteria number 1, the variance will not be contrary to the public interest. So you're really looking at, would the proposal alter the character of the locality or threaten public health, safety, and welfare? That's really what we're trying to address. Would the spirit of the ordinance be observed? It's kind of similar, and that's why we often look at criteria 1 and 2 together, because they kind of are similar. So you look at the effect the variance would have in light of the goal of the zoning ordinance. which might begin or end with review of the comprehensive master plan. So you're really looking at, is it really consistent with what the master plan might have said that this particular zone is supposed to be used for, or how it would have the character of the use, would it really threaten public health, safety, and welfare? That's why they offer are lumped together. Substantial justice is done. You know, the way the court has teed up how you analyze this issue is, would the loss to the individual that is not outweighed by gain to the general public? That is, you know, the injustice had to be such that you are in fact putting a burden on the individual, which is not justified with regard to the outcome that you want for the zoning ordinance to have in this particular area. So the proposed development, you know, you will also want to look at whether the proposed development is consistent with the area's present use. And, you know, are you in fact having a greater impact on the individual as a gain to the public is not as great, weighing the two, impact on the individual versus the benefit of the public at large. Diminution of surrounding properties, you know, would the values of surrounding properties not be diminished? This is the area where, you know, based on my experience, especially working with this, going to a lot of ZBA hearings in the city of Manchester, there's a lot of different ways this is going to come up. Everyone who's going to, as an abutter, say this is going to really have a terrible impact on the value of my property. I have it pretty frequently. We've also seen any number of ways in which applicants will try to, who are seeking a variance, convince you it's not going to have an impact. They might hire a realtor to give an opinion of value. They might have all the way up to, you know, a formal assessment of value by a real estate appraisal, and trying to really weigh impact of a particular use as proposed by an applicant of budding property. You know, I think that you really have to make your own judgment as to what's the most reliable piece of information. And I think that I think comparing the Averno case from Swansea, what you probably want to make sure is it's not just a popularity contest. You have to really assess. If someone's saying this is going to destroy the value of my property, say, well, okay, this is just a garage, or maybe it's ADU over the garage. How? Explain that to me. Why is that going to destroy the value of the property? Whereas to someone, if it's, you know, little tiny craftsman style homes in a neighborhood, if someone's putting in a McMansion, yeah, that's a pig in a poke or a skunk in a garden party. So those are the things that you have to bring common sense to make a decision. Is this really a diminution of the value of someone's property? You know, but you're always going to have those cases where they have the opinion, the realtor for the opinion of value. Every time I've heard a realtor with an opinion of value, it's pretty easy to find out they're usually involved in the transaction that come out of this situation if you approve the variance. You really begin to wonder how reliable is it. On the other hand, someone's hired a real professional appraiser who have standards they have to meet in terms of being appraisers, appraisals of value. Then you have to really listen. Oh, okay, you know, there's some serious evidence here that either supports no diminution or not. And I think it's just a question of weighing the evidence that you receive and see that. Little enforcement of the ordinance with unnecessary hardship. I think the really big way that I've seen recently in the cases that I've been deciding, you know, is in part one. You know, it's owing to special conditions that distinguish the use from others in the area. There's no substantial relationship between the general purpose of the ordinance and the application of that to the property. And again, the case I just had the other day, where there was an industrial facility that wanted to expand. They realistically only go one direction. And that direction meant they had to intrude on the side yard setback in the industrial zone. They were going to move a little bit closer to a railroad right of way. And we were having a hard time saying, how is this going to have a diminution or a change in an effect of the purposes of the ordinance for side yard setbacks? You know, as long as the railroad doesn't care, we're not prepared to say what this would do is going to cause in this particular zone that found where I live, the industrial zone, that was going to have an unreasonable impact. And certainly the proposal was reasonable. So I think that's kind of the ways that those are being about decision making. You know, is the strong argument has to be that this particular zoning requirement, particular situation, there's no fair and substantial relationship requiring strict requirement, and that the purpose of the ordinance are not being served in this instance for this particular application. Now, you can also skip down to part two, which is, you know, if you can't satisfy that, and it's reasonable, what there is the unnecessary urgent deed says if and only if, due to special conditions, the property cannot be reasonably used to strict conformance, and therefore an ordinance, a variance is necessary. That's a harder standard. It's basically a standard saying, if you don't rent me this, there's no reasonable user to make the property. And in fact, you're going to take the use of the property away from me. That's a take. It's a harder argument. The fair and substantial relationship is really the easier argument for the variance. Variance runs with the land. It's granted with respect to a piece of property, does not respect to the personal needs and preferences of the circumstances of the property owner. It really has to do with the circumstances of the property. And once granted, it runs with the land for the benefit of present and subsequent owners of the property. Special exceptions, as comparison has said that before, you know, the zoning ordinances said we will allow certain uses if you meet these requirements. So it's use permitted as long as the conditions are satisfied. And if they are satisfied, the ZBA is required to grant permission. It's not the same thing as a non-conforming use. It's a little bit different. Sometimes variances are considered to be non-conforming use. Actually, who this is, it's a use that's permitted so long as the conditions are satisfied with the ordinance are laid down as required to get the special exception. You have to have standards like your zoning ordinance with very detailed standards for special exceptions. They're very detailed, especially what I would compare to special exceptions. The zoning ordinance has a number of conditional use permits and the planning board plans. Really like special exceptions. Typically, it's the planning board's job then that is to decide whether we're going to grant a conditional use permit. But you know, not surprisingly, if you don't have clear standards in the zoning ordinance on granting special exceptions, it would undermine that special exception having a sufficient level of authority to allow legislative body to permit special exceptions without clear standards. And you know, most zoning ordinances, you know, there's within our zoning ordinance, you can have certain permissions by special exception, and then we have between 8 and 10 separate conditions each special exception has to be. So it's not easy to get them, but as long as they satisfy those criteria, there's something that has to be granted. This is a question that has come up occasionally. I don't know if you've had it before, where someone will ask for a variance for the term of the special exception. So the special exception says, yes, we can grant a whole occupation, and yes, you can have up to 5 employees, but you're going to have off-street parking for those 5 employees. The person says, well, I can get the off-street parking for 4 people, not 5. Can you modify that requirement so I can get permission to have that home occupation with 5 employees, but only have 4 parking spaces where the ordinance says I have to have 5. You have to have a parking space for every employee, assuming that's true. And the answer is no. You cannot grant a variance from the requirements of a special exception. If you can meet the requirements of the special exception, you get permission. If you can't meet the requirements of the special exception, your option to ask for a variance. It's just not cognizable for special exception to be modified by the CBA. They're supposed to be met or not met, like my board does with.
So they could get the variance first and then apply for the exception, special exception. No.
They can't, you can't ask for a variance from that term.
Oh, okay.
So what
So
you-
it's yes or no.
If your ordinance says you have to have a parking space for every employee, and you're gonna have 5 employees and you have 5 parking spaces, you can't vary that requirement. You can't ask for relief on that.
Okay.
Now, let's assume that you can't get the special exception approved. I can always come in and ask for variance. That use is not permitted in the zone. I can't satisfy the requirements for special exception. I want a variance to have a home occupation, 5 employees. That's just a straight variance, and that's not asking to vary that requirement. It's just a straight variance. So I would think it is just not appropriate ever to grant relief to change or modify special exception criteria. Special exceptions are just like variances that run to the land, not limited just the use of the avenue.
In our zoning ordinance, we have uses that are permitted. Some are permitted by special exceptions, some are just permitted by right, some are prohibited. If someone who wants to use a piece of property that's in the zoning area where there is no mention of the use of it one is permitted by special exception, you would have to go or say,
I think those were variants. You don't really have the latitude to vary the special exception requirement to meet their criteria. They have to meet the criteria to get permission. And they can't satisfy those criteria within the bounds of the language of the ordinance. Then all they could do is ask for permission to use that property for uses not permitted. And the only way you do that is through variance. And so they have to get a variance. One of the areas that I don't think you've seen this has been a number of cases recently about cumulative impact, and it kind of all started with the Brawl versus Town of Hampton, where this person saw a variance for a shed in the 20-foot setback area, and he presented evidence that there were 16 other properties all located with the same road where they had storage buildings within the setbacks. And this evidence demonstrated from their point of view that those sheds would not alter the inside character of the neighborhood. The CBA still denied, was based upon their conclusion that allowing more sheds to be built on a small lot with those setbacks creates overcrowding and is contrary to the spirit of the ordinance. So the applicant saying, allow everybody else to have it, can't you give it to me? And ultimately, I think Hampton said, this is going too far. And the cumulative impact is something that we're not going to accept. Now, the court didn't directly decide the issue, but did affirm the decision, which suggests that cumulative impact is a relevant consideration. But the Enfield case, I think, is more directly on point. So in the Foley versus Enfield case, this was a situation where the applicant wanted to build this 2-story house within this 30-foot setback on this one road area called Rollins Point. Rollins Point was a peninsula of land sticking out into a lake in Enfield. And the question that really was bothering the ZBA is whether or not, this would create more overcrowding. And the ZBA chair during the hearing process, really was concerned that if we allow this larger house to be built, there's going to have a series of other persons asking for the same relief, because this is a beautiful little peninsula. Everyone wants to have their really nice house on with water on both sides. Really cool. We want to have it. And so during the final decision making, the ZBA said that allowing this use would crowd the land and encourage others to do the same thing, and that would degrade the natural environment. And the court concluded in that case, not directly but inferentially, it was reasonable for the ZBA to take into account cumulative impact. So I think both the Enfield case and the Brawl case suggest that that's a relevant consideration. You can see what's going to be happening down the road about cumulative impact. That is a fair decision-making judgment made. That you can draw the line here, even though others have come before and got similar relief.
So you can use precedent to decide, or you can say that this will set a precedent that could have or will have negative impacts going forward.
Or I think better said, this is a step too far. That this is going to create more adverse circumstances, and it's reasonable at some point to draw a line. And I think the Enfield case is really supportive of that conclusion.
And that kind of analysis would sort of fold into the first prong of the variance, spirit and intent of the ordinance.
Yes, absolutely. It would definitely tie in there, because you have the ability to say whoa, right, this is getting outside the boundaries. The ordinance is intended to create harmonious use of the land within the environment, and that in this instance, you know, this particular Rollins Point Road was, you know, a beautiful little piece of land jutting into a sensitive environmental area, a lake. So, yeah,
So a fourth house, let's say the fifth house that's one took over one, but the fourth house was okay, so it's the exact same request, they're getting different answers.
but not really.
Well, I'm just asking.
Yeah, I suppose, you know, if at some point, you could, the board comes to the conclusion that there's going to be too much burden on this particular sensitive area. Was it the second house? Was it the third house? I don't have, I think the court probably even said in this case, as I recall, wasn't drawing that bright line, but it's a fair consideration. So every set of circumstances is going to generate a need to assess individual impacts. And so you can't draw a bright line. I'm not saying the second house or in the Peralt case, you know, there were 20 other houses that had the sheds to the side yard setback, and now this is the 21st house. Why was that sufficient basis to say it was a impact? Here, I think more likely in the Foley case, the ZBA was concerned. We're about to open the floodgates. We need to stop the flood before it occurs. Whereas the Peralt case was the flood already happened. We're now trying to make sure the situation doesn't get worse. In either case, you know, I think the board, both boards were in a sense authorized to use the concept of cumulative impact. I think that's the point I would draw for these cases.
The case is not doing.
What's that?
I think fully logic is here because the future impact of construction that haven't been done yet is within the control of this. Okay, so if they didn't think this particular property had a good impact, which is what it's taking, future impact is still logic is weird.
I think I would say you could probably argue, I think you're suggesting that the board's conclusion is going to have an adverse impact in the future is somewhat speculative, you know, but perhaps that speculation was somewhat supported by more sensitive environmental area that they were in, as opposed to in the Hampton case, the Peralt case. I don't think there's any reference to a sensitive environmental area. So it's again, it comes down to the impacts that you are assessing on the particular uses and the land in question.
The impact is going for this particular case by granting this variance. It's my belief the impact is now going downhill. Not making any determination on how steep that slope is. It could be like this, it could be a cliff, but it's going in the wrong direction. And that's why I'm saying no to that impact right now, because I see it going downward.
It's a fair way to look at the impact. I agree. Few more things and we can wrap up. By going for a while now, and I don't want to keep you up all night long. Variances have to be exercised within 2 years. Variances, special exception, unless extended to be caused by the ZBA. I would just say about the ZBA granting good cause extension. I don't think the statute was intended to allow you to grant an extension at the time of the original approval. I don't know if you had that happen where someone said, "Oh, by the way, I'm going to need 3 years on this time." Yeah, so most of the time we've got to come back in before the 2 years are over and say, "I couldn't get this. I need more time." But there is an amendment of the statute that allows you this exercising variances, special exception for 2 years. That only applies to variances and special exceptions granted on or after August 19, 2013. So the variances that might still be on the book prior to August 19, 2013, they're still out there. People can still use them, and they're good to go forever. But you can adopt an amendment to terminate old variances if you wanted to do that. I don't know if that's an issue for old variances. No, I'm just saying that's a town could do that. And the legislative body, the city council. That might be controversial. I don't know how many old variances are out there that you want to get rid of, but that's an issue. And just kind of wrap up, you know, if someone's agreed by your decision, to file a motion for rehearing. The ZBA on its own decide to have a rehearing. You think you've made a mistake and you want to deal with that mistake before the 30 days are up, you can do it on your own. I would say normally you hold a meeting to decide whether the grant or denied rehearing, and it's based upon the submission. Normally you don't hear from the parties, you just look at the paperwork, decide whether to grant or deny the application. You hear the case, and if you do hear the case, if the hearing is granted, you may consider certain issues or rehear the entire case. So you could actually decide to say, oh, the applicant has made an argument we were wrong on some element of denying the variance. We'll rehear the case only on that. We're not going to rehear the whole case to deny. Or you can decide we're going to hear the whole case to deny. That's really up to you.
Couple questions on that. If an individual, I mean, how does, if the board sua sponte decides that it wants to rehear another one of its applications, how is that noticed in the meeting, in the public agenda? Can somebody just bring that up without that having not been noticed?
Well, yeah, you could.
Really?
You because think about it for a second. Well, first of all, I suppose the concern would be, well, doesn't both parties have notice and opportunity to be heard? But that's an issue. But normally, when you're deciding whether to grant or deny a hearing, you don't have to hear from anybody. That's just an application. So if I was at a ZBA meeting, that's 2 weeks after we made a decision, and I say, you know, Madam Chair, I think we made a mistake. I think we did the following thing. We granted that relief or denied that relief. I think we ought to really rehear that case. And we can do that because the 30-day appeal period has. I think that would be an action that could be within the order of the board to take. And I don't think the law would say, before you do that, you have to give notice and opportunity to be heard, either you get supporting or opposing party. Now, I suppose there's an argument that denies due process, but you're only doing the things you think is better, all concerned, to rehear the case before a mistake is made. You're not taking away any relief. You're saying we're just going to rehear the case and decide whether or not we're going to stick with the decision we had. But think about it, I suppose, if you only have 30 days to do that, what would you do? You would, well, let's assume you're meeting every week, and last week you made a decision.
Or it just feels like it.
We only usually meet once a month.
So how would you implement taking that action on your own to file a motion for a hearing? You have to do it within 30 days, and if you don't do it within 30 days, you can't.
It would be a new agenda item for every CBA meeting prior to whole businesses. Member rehearings.
Well,
No, because you're before, what he's saying is that it would be outside of the 30-day time.
yeah, you can't do it outside.
Oh, yeah, but that, you would think that our meeting would be within 30 days of our last meeting.
Well, I suppose what you could do, you could say, let's say, in the middle of the night, you wake up, realize, oh crap, we screwed that up. And so you contact staff and say, you know, at the next meeting, we're gonna put this on the agenda. By the way, let's send a letter to the applicant and the main abutters or whoever they are and say, we're gonna have a agenda item to discuss whether the board will on its own grant a motion for a hearing. And that's the only way you could really somehow do it in a timely fashion and then give everyone an opportunity to be heard. And you might
start the meeting, so
maybe, but it would have to be a serious, you're not gonna do this out of the blue all the time. It's gonna have to be a really serious issue. You want to avoid making a mistake before it goes to spirit.
middle of the night.
And maybe you would only do it after consulting with counsel.
Even trickier now with the new rule that says you have facts. To back up each of your 5 criteria. A fact being as much of a fact as you can have. And there's no way to know whether that request is influenced by information that you didn't even have at the time of the meeting, which it probably shouldn't be, right?
I'm not sure how really to answer that question. I guess I'm just trying to fit myself into a set of circumstances, really does make sense for the board to rehear a case. I suppose, a serious failure or opportunity to participate, what if, you had someone, leave a message with Peter, who was the principal of Butter, and they were home with COVID and their Zoom link went out and they couldn't participate, and you went ahead with the hearing anyway. And you said, no, I'm not gonna bother with that. You're not here, I'm gonna listen.
So that's.
And then you reconsidered, so wait a minute, that
Or
was
something in
was.
the application is considerably wrong.
Or something where you really realize, no, we can't do that. We have to really have that person have a chance to be heard. So I'm thinking more like you just come to the conclusion there was something seriously deficient in how you made the decision, either through participation, not letting someone be heard because they couldn't be in the room or whatever, or some other, I suppose the health issue, let's just say, this last minute memo has this materially disastrous effect on an application, I suppose, is that something where you really think that was denying someone a chance to be heard correctly? I'm not sure how to fit that in.
Yeah, that was.
So,
Was a rehearing.
oh, okay, so, how realistically you implement this power on your own, grant a motion for rehearing, I don't have all the nuances, but it's.
Well, I mean, is there, we could do it through the aid, basically, to
Do what?
do it through our aid and say, I mean, say one of us says, I think we really got this wrong, and then we call Peter, and Peter can then put it on the agenda.
And give notice by me, email or letter to the parties, right?
I mean, not that I'm thinking of doing this, but I just try to think about it. No,
You're right.
let's leave it up to Peter.
What's that?
The staff, Peter be the appropriate.
Yes, that would make sense. I mean, I don't know how you do agendas, but maybe, I don't know, many ZBA rules will have, the agenda imposed in consultation with the chair, and the chair has some discretion. What goes on the agenda, I don't know how.
By application,
Okay.
with staff reports and
Right,
everything's in it.
okay. So that's rehearings. When you do the motion for rehearing, really, I guess, keep in mind that the Supreme Court really believes there has to be finality in ZBA decisions, so you're really not supposed to grant them lightly, which I'm sure you don't. But if the person has demonstrated the board really committed a technical error, or, there's really new evidence that's not available at the time of the first hearing, it might be meritorious to grant a motion for a hearing to rehear the case. It should reflect changing conditions, but if someone's got new evidence and they have the opportunity to submit it beforehand, at the first hearing, and they're just dilatory in getting the stuff to you, that's usually not a basis to grant a motion for a hearing.
You said it's technical. So is that
A technical error,
what judgment?
Well, let's assume you granted a variance and you failed to address the hardship element in granting the variance. You just missed it.
Sorry, but what if it's not that way, every element is addressed, but in retrospect,
I suppose, let's say, for some reason, you all decided that there are relatively no diminution surrounding values, that's to surrounding properties, but, maybe for whatever reason, you're blinded to some aspect of that argument, and you all realize, wait a minute, we really kind of messed up on it. That big mansion next to that beautiful craft home, that's not gonna work. So I think it really depends on the circumstance. I don't know that I have a bright line.
depends on, yeah, I don't want to.
Yeah. So beyond the rehearing, the appealing party can appeal the Supreme Court or also to the Housing Appeals Board. The record is really what the sine qua non of everything you do here is in the record. If it's in the record, it's the evidence that supports your decision. And You know, I spent a lot of time in the old days when I was doing these cases. I put huge amounts of time putting the record together. I had it paginated, organized, and I'm sure your staff does that thing here. Because, and when I would submit it, I would make sure I would underline the stuff I wanted the judge to look at, and I would make sure that they knew what pages it was on. Because my job was to show there was adequate evidence to the record to support the board's decision. I never had to prove what the CBA did was correct. I only had to show what they did. What they did was based on evidence in the record. That's the key thing ultimately when you're dealing with these appeals. And the last thing I want to say, I don't know if you had access this, but there is this zoning board of adjustment handbook, which is available from BEA. And so you can download it. And I have that on my desktop, and I oftentimes refer to it. You know, it's a digital document, so it's easy to search, and it's really good reference guide for being a member of the CBA. The other thing, which I'm sure, I don't know if you all have, and we all, yeah, I always have this, you know, it's, and the annotations of the cases for all the statutes, those are all also very helpful. So with that, I've overstepped my welcome, but I want to thank you for inviting.
I also have Peter's phone number, so that's okay. So not that people.
No, I have an electronic copy of all of these publications, and I use them all the time. I want to have an answer to a question I often look at.
Thank you. Thank you very much.
Thank you. That was fun.
Okay, well, good. Well, and you know, we are available.
Got you any questions?
Oh, great. Thank you.
Somebody else.
Well, that's all. Well,
No, we don't.
You would have. You would have.
Yeah. Do you want the?
yes, okay, yeah.
You just wanted that. You just heard that.